Greetings, esteemed viewers. Welcome to Law Logical, where we break down the complexities of legal jargon into easily understandable language. We are here to unravel the intricacies of the law, to make it accessible and comprehensible for everyone. No more feeling lost in the labyrinth of legalities. We are your trusty guide. Today, we embark on a journey to explore a topic that has been the center of many discussions lately: the divorce laws in India. We will be dissecting the Hindu Marriage Act of 1955, a pivotal legislation that has governed matrimonial disputes for decades. But that's not all. The legal landscape has undergone significant changes recently with the introduction of new divorce rules in 2023. We'll be delving into these amendments, helping you understand how they might affect you and what they mean in the grand scheme of things. Stay tuned as we delve into the nitty-gritty of the divorce laws in India. Before we jump into the heart of the matter, it's crucial to understand what divorce is. Divorce, in its simplest form, is the legal dissolution of a marriage by a court or other competent body. It's a process that ends the bond of matrimony between a married couple under the rule of law of the particular country or state. Divorce often involves the reorganizing or cancelling of legal responsibilities and duties of marriage, thus dissolving the bonds of matrimony between a married couple. It's a complex process that can involve issues of alimony, child custody, child visitation, access, parenting time, child support, distribution of property, and division of debt. Over the past few decades, divorce rates have been on a steady climb globally, and India is no exception. This rise can be attributed to a myriad of factors, including changes in societal norms, financial independence, and more. Now that we've established what divorce is, let's understand the legalities involved. India, with its diverse culture and religions, has different laws to govern the institution of marriage and divorce. In the rich tapestry of India, where a multitude of religions and cultures coexist, the legislation surrounding divorce is as diverse as the people themselves. Different religious communities have their own respective personal laws governing matrimony and its dissolution. For Hindus, Sikhs, Buddhists, and Jains, the Hindu Marriage Act of 1955 is the guiding framework. Muslims are governed by the Dissolution of Muslim Marriages Act 1939, while Christian divorces fall under the Indian Divorce Act of 1869. Parsis have the Parsi Marriage and Divorce Act of 1936. And for those who do not fall under these communities or prefer a secular approach, there's the Special Marriage Act of 1954. Today, we will focus primarily on the Hindu Marriage Act of 1955, a law that has not only shaped the course of countless lives, but also reflects the societal changes of the times. This act regulates marriage and divorce among Hindus and those deemed to be within its ambit. It outlines the conditions for a valid Hindu marriage and stipulates the grounds on which a marriage can be legally dissolved. The act was a landmark piece of legislation, a progressive stride towards codifying and reforming Hindu law. It sought to abolish certain regressive practices and give both men and women equal rights in marriage and its dissolution. However, it's vital to remember that the act isn't static. It has evolved over time, reflecting changes in society's attitudes and norms. Various amendments have been introduced to address emerging issues and to ensure that the law remains relevant, fair, and just. So, whether you're a law student, someone going through a divorce, or just a curious mind wanting to understand the legal landscape of India, understanding the Hindu Marriage Act of 1955 can provide valuable insights into the interplay between law, society, and personal life in India. With that overview, we can now delve deeper into the Hindu Marriage Act of 1955. The Hindu Marriage Act of 1955 regulates the divorce process for Hindus in India. This legislation was a landmark event in the history of Indian law, establishing clear provisions for the legal separation of Hindu couples. Under this act, divorce can be sought on various grounds. The first is adultery, where one spouse has had a voluntary sexual relationship outside of their marriage. The second is cruelty, which can be either mental or physical. In this case, the aggrieved spouse must prove that their partner's actions have caused them undue harm or distress. Additionally, desertion for a continuous period of not less than 2 years is also considered a valid ground for divorce. This refers to instances where one spouse abandons the other without any reasonable cause or consent. Other grounds include conversion to another religion, unsound mind, and a chronic and incurable form of leprosy or venereal disease. The Act also considers a presumption of death if a spouse has not been heard of as being alive for a period of 7 or more years. Furthermore, the Act provides for divorce by mutual consent. This is a provision where both parties agree to part ways amicably. It involves a cooling-off period of 6 months, allowing the couple time to reconsider their decision before the divorce is finalized. The Hindu Marriage Act of 1955 was a significant advancement in providing a clear legal framework for divorce. However, it's important to note that societal norms and understandings of marriage and divorce have shifted considerably since the mid-20th century. In response to these changes, amendments have been introduced over the years to ensure the Act remains relevant and fair. These amendments have sought to address issues such as maintenance for the wife and children, property rights, and the introduction of no-fault divorce. Now let's move on to the recent changes in this Act. These amendments, particularly those introduced in 2023, bring about significant changes in how divorce is approached under the Hindu Marriage Act, reflecting the evolving societal dynamics. Stay tuned as we delve into these changes in the next segment. The year 2023 brought about significant changes to the divorce rules under the Hindu Marriage Act. A clear shift was seen towards more egalitarian laws, reflecting the evolving dynamics of Indian society. Firstly, the cooling-off period, which previously lasted for 6 months, was waived off in certain cases. This amendment aimed to expedite the legal process for couples who mutually agree to part ways, reducing the emotional and financial strain. Secondly, the law now recognizes irretrievable breakdown of marriage as a valid ground for divorce. This was a significant step as it acknowledged that sometimes reconciliation is not the best course, and couples should be allowed to move on. The third change was in the realm of property rights. The amendment made it clear that both spouses have an equal claim to the property acquired during the marriage. This was a landmark move, ensuring financial security and independence to both parties after divorce. Another noteworthy amendment was the introduction of the right to reside. It ensured that a woman could not be forced out of her marital home during the divorce proceedings, thus providing her with a sense of security and stability. Moreover, the amendments also addressed the question of alimony and maintenance. The law now mandates a man to provide financial assistance to his ex-wife until she remarries or becomes financially independent. This change was aimed at ensuring that women are not left in a financially vulnerable position post-divorce. Lastly, the law now emphasizes on mediation before moving to litigation. This is to encourage amicable settlements and reduce the burden on the court system. These amendments have not only made the divorce process more streamlined, but have also brought about a more balanced approach, taking into account the rights and responsibilities of both parties. They have ensured that the law keeps pace with the changing social norms and realities of the Indian society. These changes have indeed altered the landscape of divorce laws in India. Divorce laws in India, like any other legal subject, are multifaceted and constantly evolving. We've taken a journey through the intricacies of these laws, from the establishment of the Hindu Marriage Act of 1955 to the recent amendments in the divorce rules of 2023. The evolution of these laws mirrors the changing societal norms and the ever-growing emphasis on individual rights and equality. In our discussion, we've understood that the concept of divorce, while being a legal dissolution of marriage, is deeply intertwined with various social, personal, and economic factors. We've delved into the Hindu Marriage Act of 1955, a significant legislation that governs marriages and divorces amongst Hindus in India. This act has been a cornerstone in Indian family law, providing a legal framework for matrimonial issues. We've also examined the amendments in the divorce rules of 2023, which have brought about significant changes in the legal landscape of divorce in India. These changes, while aiming to simplify the divorce process, also make a concerted effort to ensure that the rights and interests of both parties are protected. The importance of being knowledgeable about one's legal rights and responsibilities cannot be overstated. Understanding the laws that govern us, particularly those related to personal matters like marriage and divorce, empowers us to make informed decisions. It allows us to navigate the complexities of the legal system with confidence and clarity. Law, like the society it serves, is a living entity. It grows, adapts, and evolves. Staying updated about these changes not only enhances our understanding of the legal system, but also helps us adapt to these changes effectively. If you found this video helpful, do like, share, and subscribe to Law Logical for more such insightful content. And if you have any queries, feel free to drop them in the comment section below. Until next time, stay informed and stay safe.